Hi, I'm Brad Mavis, and I want to remind you that while I have smart tax attorneys and tax professionals working for me and for our clients, I am not an attorney, and I'm certainly not your attorney. So I wanted to take a minute today to talk about contingency fees as it relates to the tax world, in particular, charging contingency fees in conjunction with preparing and filing refund claims. And so there's a lot of talk about there around this and a lot of different opinions on, is it appropriate? Is it permissible? Is it even legal to charge a contingency fee when working with a client on a refund claim or just even a regular tax return? And so I was recently at an in-person IRS training session as it relates to the employee retention claim. And one of the statements that the agent made in this seminar was that contingency fees violate Circular 230. And so he was very clear on that. Contingency fees were not permissible under Circular 230. And so there's a lot of talk about, well, what does that mean for a CPA who may have assisted a client in filing for the ERC, the employee retention credit, or other type of tax credit, maybe whether it be research and development or otherwise. And so what does that mean for a CPA who has who has charged a contingency fee for a client? Does that put their license at risk? Does it expose them to penalties or other issues in front of the IRS, potentially losing their license? And so I wanted to talk about that because I've had a lot of conversations with different folks, whether they be tax attorneys or CPAs or other folks that we are working with. And there's a lot of opinions about this. One of the things I noticed was that nobody actually ever took the time to tie back their opinion to actual precedent. And that's something that's super important. If you know, whenever you're doing anything related to taxes, having supporting documentation behind it. So I wanted to talk through a very seminal court case that talks about contingency fees and addresses this exact concern specifically for CPAs who are filing ordinary refund claims and how that interacts with Circular 230 and other regulations that may be out there. So if we go back and we look at the employee retention credit, which is one of the largest, most popular tax refund claims that has been in existence for the past 3 years, the vast majority of folks out there who were working with clients to manage this process were charging contingency fees, and that includes tax professionals, tax preparers, CPAs, and the like. Not everybody, a lot of them did. And so this particular court case looks at and asks the question, are contingency fees permissible when preparing and filing in what's called an ordinary refund claims? There's a very particular definition around that. And so as we all know, a taxpayer may undertake the filing of an ordinary refund claim if the taxpayer determines that he or she has overpaid his taxes. If they determine that they've overpaid their taxes, they're entitled to request a refund of those taxes. And that, at the core, when you look at the employee retention credit or other types of tax credits, that's effectively, what the client's doing is, are they, they realize they overpaid their taxes and they're asking for a refund. So, in these scenarios, the taxpayer could hire CPA or another tax preparer, including perhaps an EA, a tax attorney, or other professional, particularly if these tax credits are complex. And again, you'll use the ERC as an example, which the IRS, and we all know, is a very complex tax credit. There's a lot of rules around this. And so the taxpayer has a right to hire a professional to assist in this process. And so as it relates to the IRS rules and regulations, we all know the IRS regulates the tax industry. In fact, the rules that state that the IRS is going to regulate the tax industry go back to 1884. In fact, it's USC 31 section 330. And back in 1884, Congress made it very clear that the Department of Treasury has the ability to regulate the practice of representatives of persons practicing before the department, right? So regulations governing the practice of practicing in front of the Department of the Treasury. And so similar to the way you would practice before in front of a court, if you're going to be representing somebody and practicing before the Department of the Treasury, the IRS, the Department of the Treasury has the ability to regulate this, and the IRS is part of the extension of the Department of the Treasury. So today, the regulations governing practice is commonly referred to Circular 230. And Circular 230 is pretty clear, right? So Circular 230 says that a practitioner may not charge a contingent fee on any matter before the Internal Revenue Service, right? So Circular 230 applies to anybody, any tax practitioner. And it very clear is that, except in very limited situations, a practitioner may not charge a contingent fee on any matter before the Internal Revenue Service. And so a lot of folks turn to that and say, well, look, Circular 230 says it. You can't charge a contingency fee. Anybody who charges a contingency fee, they're in trouble. They're going to face enforcement action. And so when you dive into the details, specifically within Circular 230, there's section 1027. And it defines what they say any matter, right? So, the IRS says that, the practitioner may not charge a contingency fee on any matter. So what does any matter? Well, it's pretty broad, right? And any matter includes preparing or filing or assisting in the preparation of filing returns or claims for refund credits. So at first glance, it seems that refund fees are kind of a no-go. So if you're a CPA or tax professional charge a contingency fee on filing a refund claim, what are your options? What are you supposed to do? Well, herein comes in Gerald Ridgely, who's a CPA. And Gerald Ridgely, back in 2013, filed a lawsuit, proactively filed a lawsuit, sued the Department of the Treasury, sued the Commissioner of the IRS, because he said that he was suffering a loss of clients and significant revenue, and that his ability to represent and assist clients has been severely restricted by the Commissioner, by the IRS, and by these rules that were promulgated that CPAs could not charge a contingency fee. And so this was a really interesting court case, because this court case looked specifically, Joe Ridgely was preparing refund claims. And he said, hey, wait a minute, I'm a CPA, I'm a licensed individual, and these rules are actually causing me to lose clients and lose significant revenue, because now my ability to represent and assist my clients has been restricted by these rules. And he said, that's not right. That's not fair. And the reason it's not fair is because it violates the Administrative Procedure Act. And so oftentimes we see regulation and we read the regulation circular 230, say, oh, it makes sense. Can't do it. And yet the IRS and the courts, when they're looking at administrative procedures, have a slightly different approach to this, right? Because they're not arguing whether or not there was a violation of this administrative procedure. They're looking at, is the administrative procedure even correct to begin with? Is it even appropriate? Did the IRS, did the Commissioner, did the Department of Treasury, did they even have the rights to make this rule in the first place? And so when they're reviewing administrative procedures, this requires courts to look at the action and to hold, quote, hold unlawful and set aside agency actions, findings, and conclusions that are in excess of statutory jurisdiction or authority, right? So in other words, is the government agency operating in excess of what Congress has permitted it to do? And so the question is, when the IRS said that, basically made this broad statement, that a CPA can't charge contingency fees, did the IRS exceed its statutory authority in limiting contingency fees into a small category of examples? And so in this court case, the court analyzed exactly that, right? And so when they were going through this, they have to use what's called the Chevron standard. And so if you're an attorney and you're arguing over administrative law, the Chevron standard is probably pretty familiar to you. But for those of you who might not have a lot of background on this, I did a little bit digging on this, and this is a critical standard, right? So two questions. One, has Congress directly spoken to the issue at hand? Right, that's number one. If an agency is in conflict with what Congress says, well, Congress has the authority. And if Congress hasn't directly spoken to it, or if Congress has spoken to it, but it's vague and it's not very clear, is the regulation that the regulator came up with, is it permissible, or is it arbitrary, or is it capricious? And so the court looked at this, and so the answer might surprise you what they found. And so I know we've already been a little technical, but I'm going to go get a little more technical. So back in 1884, almost 150 years ago, Congress clearly authorized the Treasury to regulate the practice of representation before the Department of Treasury. And so the question becomes, well, what defines practice and what makes you a representative? Well, Ridgely said he wasn't practicing and he wasn't a representative. Well, the IRS said, well, no, by definition, you're filing refund claims. So yes, you are practicing. And so, this is related to your client's tax liabilities. You're practicing. And so the question becomes, and became in this court case, do CPAs become by definition representatives who practice before the IRS when they prepare or file ordinary refund claims or ordinary returns? And so, as it related to this court case, as they prepare ordinary refund claims. So the question became, are CPAs by definition representatives who practice before the IRS when they prepare and file ordinary refund claims? The courts looked at this and they determined that Ridgely was not a representative and he was not practicing. And I'm summarizing a lot of legal details here because there's a lot of precedent, other cases they looked at and other things, but the courts determined that Ridgely had neither the authority to bind his clients, which is a key component of being a representative, and he was not practicing. And so what the court said is that a tax professional is not practicing before the IRS when he simply assists in the preparation of someone else's tax return. So that's really interesting here because the courts clearly made a distinction between assisting in preparing a tax return or a claim for refund and practicing before the IRS. So that's really interesting. But the case doesn't stop there. And I think it's even more interesting. The deeper you go into this, the more interesting I found it. And so courts went on to say say that even if the above, isn't true, but if they were to go on and take the IRS's arguments that by definition, every time a tax preparer submits a tax return, that they're effectively practicing for the IRS, that this would, quote, effectively gut Congress's carefully articulated framework for regulating those who are preparing and filing ordinary tax returns and refunds, right? So as you may be aware, there's a huge industry around tax preparation, tax advice, tax support. And so what the courts found here is that Congress had actually very carefully articulated a framework for regulation as it relates to those who prepare and file ordinary tax returns, and that this is distinct from practice in front of the IRS, right? So there's a distinction, and they go into it in the case, but there's an order of operations, and it depends on what you're doing and when you're doing it that determines whether or not you are practicing in front of the IRS or you're simply preparing the tax returns. Now, as it relates to Congress, Congress put together a very specific, there's a laundry list of penalties and related to tax preparers that engage in fraudulent activity, frivolous refund claims, taking unreasonable positions, reckless conduct, aiding and abetting, all of these things that we expect our tax preparers not to do, right? We assume they're not going to do that. And for those who do that, there are specific penalties and incredibly firm penalties for folks who engage in this fraudulent behavior, as there should be. But the preparation activities, as the court found, related to contingency fees are fundamentally different from practices before the IRS. And according to the court, clearly indicates that Congress conceived of tax return preparation and tax refund preparation as two similar activities that are qualitatively different from the quote-unquote practice of presenting or adjudicating cases in front of the IRS. And so while ultimately the IRS presented counter arguments, obviously they saw it differently, the court ruled rather forcefully in favor of Ridgely's CPA. And I think the ruling is very interesting as well, because the ruling stated not that the IRS lacked statutory authority to promulgate the contingent fee restriction and provided not a temporary injunction, not monetary damages, but permanent injunction to the IRS from enforcing this regulation. And the reason they issued this permanent injunction, which is the last and it's permanent, is that they went through a deep analysis as well and the court determined that Ridgely suffered irreparable injury and that the remedies available to Ridgely, such as monetary damages, were insufficient to fully compensate this injury, among other things they analyzed. And so this is a really interesting court case because very clearly the court determined that when filing ordinary refund claims, that it's permissible to charge contingent fees, that it doesn't violate Circular 230, that it doesn't violate Section 330, that it's not in contradiction to this, and in fact identified a significant distinction between practice before the IRS and tax preparation. And so I wanted to walk through that, because I think it's an important court case, and for the many folks out there who did charge contingent fees and are somewhat concerned about this, there is a precedent there, assuming that your situation matches and mirrors what was contemplated, what was reviewed in the Ridgely case. There's a precedent there. So again, my name is Brad Mavis, and this is a reminder, as I said at the beginning, is that I want to remind you that while I have smart tax attorneys, tax pros working for me and my clients, and a lot of experience in the employee retention space and analyzing these cases, I am not an attorney, and I'm certainly not your attorney, but we want to help. So please reach out, schedule time to speak with me, one of my team members, to review your unique situation, your unique set of facts and circumstances, and we can see how we might be able to help you or your clients navigate this. Thanks.